Welcome to the first newscast of the organisation, the Victims of Abuse in the Australian Defence Force, the VA-ADF, and I am your presenter, Rohan Collins-Rowe. In this bulletin, the stories are the VA-ADF, who are they, and secondly, DART, the Defence Abuse Response Task Force, and ADF, how they conned everyone. VA-ADF represents victims of abuse, torture and rape in the ADF. It has members in every state of Australia, from the ordinary ranks of every service all the way up to Air Commodore. VA-ADF received no funding from any government body or source that would compromise its independence. So, what is abuse? Abuse is the perpetration of serious criminal behaviour under the Commonwealth Crimes Act of 1903 and the Criminal Code 1990. It is the perpetration of abuse and then the cover-up by those above, around and below the victim. This also involves the criminal use of ADF's bureaucracy and command. It is abuse and torture within the meaning of several international conventions. After the abuse, the cover-up extends to more criminal offending. That is, it results in the theft of superannuation and healthcare entitlements by way of the victim's mode of discharge that ADF imposes and then refuses to correct. ADF misuses its power and leadership to prevent future wrongs by covering up historic and current abuse, tortures and rapes wherever possible. ADF, by not clearly defining what is abuse and then making it clear to the troops and following through without fear or favour, by removing from the services forthwith those who cannot or will not follow command, aggravates the problem. However, this definitely does not include Defence finding some sacrificial scapegoats and then sacrificing them on the altar of expediency. The VA-ADF mission is to secure a restoration as opposed to only a compensation for all victims. The VA-ADF advocates for victims as individuals and victims as a group. The VA-ADF mission is also to encourage and educate debate within Parliament, government departments, the people of Australia and indeed the ADF on what constitutes abuse, why it occurs and the most effective ways to combat abuse, as well as to reveal the true cost of abuse so that it is listed as a line item in the budget. The Parliament may monitor the cost of abuse and efforts to reduce it. Added to this is revealing fraud, waste and mismanagement. Why? Because these three are so often tied into Defence's arrogance that crimes and cover-ups are a way of military life, before, during and after the fact, especially in high and mid-level officer ranks. It's called protect your career at all costs. VA-ADF intend to make plain why efforts so far have been half-hearted and tokenistic. Here are some examples of items and areas that are of interest to VA-ADF. Firstly, regarding the informing of Parliament that I spoke of earlier, Defence no longer sees itself as answerable to Parliament as a whole and is quite open about this. Defence has removed any reference to being answerable to Parliament in its corporate plan of 2015-16 and has replaced this with answerable only to the government of the day. Might the VA-ADF and perhaps some parliamentarians remind Defence that we are a parliamentary democracy, not a government of the day democracy. Nearly all governments of the day do not have a majority in both houses. Parliament as a whole appropriates money for defence and joint parliamentary committees scrutinise defence. Also, since when is Defence a corporation? Defence are servants of the Crown. Another example is the Defence Abuse Response Task Force, or DART. It produced inconsistent outcomes and many victims were cut out by lack of advertising for the DART and an early cut-off time for applications. Still another example, the Royal Commission into Institutional Responses to Child Sexual Abuse only gave ADF a drive-by examination in the shadow of a federal election after the writs were issued. How convenient. VA-ADF maintains, as the Royal Commission and Defence would have been and should have been political dynamite, that a detailed examination should have been given to Defence. Contrast this to the detailed inspections of many other institutions which are currently receiving an even closer scrutiny as I speak. Victims nearly always have serious difficulties with Department of Veteran Affairs claims as well. Victims' files are altered after the fact, or the relevant information is simply not there. The files are sliced and diced. DVA knows this, but DVA often relies on the information that Defence gives it about a victim. How convenient. Clauses in the DVA Acts also work against victims. So, VA-ADF has a keen interest in the DVA. VA-ADF will also draw upon Defence-related Freedom of Information requests and questions on notice, along with the answers that are provided. So, to achieve the VA-ADF aims, this presentation and others that will follow will have news, stories and editorial comment. Various links will be provided to the source material when in our consideration it is safe to do so. Therefore, we encourage all concerned electors to contact and engage with their Members of Parliament and Senators about the issues that will be raised in this and future programs. Please note that viewer discretion is advised, that some stories may contain distressing elements and emotional triggers for victims. We will give this advisory when stories may contain this sensitive material. The Defence Abuse Response Task Force, or DART, and Defence, how they conned everyone. A strategy was devised to minimise the public and financial fallout of the abuse, torture and rape scandals. Welcome to Background Story. DART had its creation in a series of officially commissioned reports into abuse in the ADF. It was announced soon after the apology to victims of abuse in Parliament by the then Defence Minister Stephen Smith in 2012. It was in response to growing numbers of rape and abuse scandals in ADF being revealed. The leading example of the public disgrace of ADF at that time being yet another Australian Defence Force Academy affair, the Skype scandal. The text of the press conference 26 November 2012 with Minister Smith, Elizabeth Broderick, at the time the Sex Discrimination Commissioner, and Len Roberts-Smith showed the inability to grasp with all forms of abuse was beginning. The focus was to be on female rape at the expense of male rape, bashings, tortures. Elizabeth Broderick's work would be used to fix the PR disaster, and we will return to this soon. Officially, Len Roberts-Smith, the new head of DART, volunteered his services. Therefore, the head of DART was Major General Len Roberts-Smith QC. Yes, a learned legal man. A judge, no less. But a Major General, an officer in the ADF. Did anybody think that this would not be appropriate? That ADF must be seen to be removed from the very body that was going to investigate it? Did anybody consider that Len Roberts-Smith would treat DART as his own personal kingdom, trampling on established protocols and principles in laws such as you cannot be judged in your own cause, apprehended bias, and respecting the law of agency? Apparently it is standard operating procedure for Defence to be its own judge and jury wherever possible, if it can get away with it. So back to the many disgraces of ADF. Before the Skype scandal, there is the ad for 24, Advert 24 refers to 24 unresolved cases of rapes and other sexual abuses at the Canberra Military College, where our new officers are supposed to be informed. Advert 24 incidences occurred in the mid to late 1990s, and some perpetrators have now risen to middle and senior ranks in ADF. A series of Defence Ministers and ADF were well aware of the implications of the Advert 24, although the story had not entered the public consciousness in a big way yet. Things were still a series of disconnected rumours. It would be 2014 before the Four Corners does their Chamber of Horrors report that breaks the story open. It was here Len Robert-Smith attempted to preserve his pride on camera in Chamber of Horrors in response to probing questions by Four Corners journalists. So, on camera, Len Robert-Smith reopened applications for DART, but only for females who were cadets at the Australian Defence Force Academy, a select group at the expense of all other victims. Where was the equity? Once again, Elizabeth Broderick's influence with a female-only bias had spread far and wide. Because these scandals involved sexual assault and rape of women members in ADF, the result was the document Pathways to Change. It resulted in placing abuse in a pyramid hierarchy. Elizabeth Broderick's work again. Defence's actions here were much less about doing what is right than the appearance of doing what it believed Parliament and the Australian people would buy into. Now, Defence also commissioned the legal firm DLA Piper to produce a report into abuse and sexual assault in the ADF. Things were so bad, the report was split in two. Number 1 would be available. Number 2 has never been released, so explosive is its content. This also reveals Defence's woeful understanding of the structural mechanisms within ADF that lead to abuse, torture and rape, and that using gender as a means of cultural change was and is doomed to failure. One would think ADF would have got it by now. One can only assume Chiefs of Defence all saw their career preservation as a first priority. So DART was compromised in many ways right from its beginning, and it was slowly subverted even more during its lifespan. Defence, who was responsible for advertising DART, did so only in major metropolitan newspapers and for a very, very limited time. The failing here is that a majority of victims actively avoid news about Defence, especially news about abuse. Many victims are country and rural based and do not engage with major metropolitan newspapers. The damage done to victims is still raw or has solidified in many older victims who use avoidance as a key coping strategy. Many victims never qualified for any mental health help from DVA. Defence was and is clueless. This led to many victims of abuse in the ADF not finding out about DART until after DART had closed its books. Even then, VA ADF had to battle DART to get a member admitted for assessment. This came about after Len Roberts' opening of DART for female members from the Academy. But Len Robert-Smith made it very, very difficult. His bloody-mindedness meant that an extended battle had to be fought to get this member admitted. This wasn't particularly Elizabeth Broderick's work this time. So to DART's assessment groups. It assessed victims from Category 1 to Category 4. Category 1 was the least severe, Category 4 the most severe. Category 4 attracted a top payment of $45,000. A further category of 5 was added for cases where defence mismanagement occurred. This is interesting because there are provisions for the worst cases of governmental and bureaucratic mismanagement to award up to $250,000. Defence seemed more worried about their budget than doing the right thing by victims, with what would amount to small change from a $30 billion budget. The poor diggers. In setting up DART, nobody wanted to consider that mismanagement of victims was so bad and so widespread. Although it was in the capacity of DART to do so, it refused to fix this major oversight. Also, many victims have a level of distrust that made them feel they did not have a choice but to use lawyers. DART and Len Robert Smith should have understood plainly from the horrendous material crossing their desks, but they chose to turn away again. DART made sure that successful victims were liable for their own legal costs as well. It raises eyebrows that someone successful has to pay their own costs. Further, it is also curious that DART categories and payments mirror the now totally discredited Catholic Church scheme for its victims. VA-ADF records show that victim categories were downgraded approximately midway through DART's lifespan, depending on when the victim's claims were being processed. So, early victims who were assessed as Cat 4 were okay, and the early Cat 4s held on to their assessment. But later victims with similar abuse stories were downgraded to Cat 3. From now on, only female victims who were raped on base would receive Cat 4 recognition. Female members who were raped or sexually assaulted off base by their comrades in arms were now to be assessed as Cat 3. Example, a Navy ship on deployment overseas, raped in the onshore accommodation by a crewmate, this accommodation provided by Navy. Voila, a lesser crime. If you were unhappy with the decision of DART, though, they would review it. They rarely changed their mind. However, DART was not adverse to using their systems to punish vocal victims who were critical of DART. A victim who was found to be in scope, when asked for a review, was found to be totally out of scope, apparently as punishment for evidence that he gave to the Senate Foreign Affairs, Defence and Trade Committee. More flaws followed. Many victims asked for a change of discharge. The mode of discharge is very important, and I referred to it earlier. Most victims were discharged, services no longer required, or discharge at own request. So victims through DART requested a change of the mode of discharge to medical. Defence and service chiefs failed to follow through on this point, although they had the power to do so. This change is pertinent regarding making a claim with the Department of Veteran Affairs or DVA and military super. It's even more so when most victims of abuse have defence records that were tampered with, sliced and diced, and Command knew of this. Victims could not access counselling until after their claim was fully assessed and accepted. Victims were made to relive the abuse with the writing of statutory declarations and so on for DART, and then left with reopened wounds to fester, dealing with the full range of emotions brought up by the reliving of their abuse. There were unreported victim suicides on DART and Len Robert Smith's watch. When a victim applied for records from DART for the purposes of making a DVA claim, they were so heavily redacted, blacked out, as to make them absolutely useless. Finally, DART placed the whole restorative engagement meeting with senior people in defence under a confidentiality agreement to protect defence. Once again, poor defence. They're very, very sensitive. So DART was subverted, but it was a start for the independent investigation of criminal acts of abuse in the ADF. Its replacement, the Commonwealth Ombudsman, can't even do that. The Ombudsman can take no action other than to refer the victim back to ADF for a resolution. Let me repeat that. If the Ombudsman finds abuse has occurred, the Ombudsman refers the matter back to ADF for ADF to investigate itself. You cannot be judge in your own cause. Justice must not only be done, it must be seen to be done. Apparently, ADF, with its head wrapped up in its solemn power, sees itself as above the law, above Parliament, above the minister too, as many past defence ministers have found out. So, in finishing up, over future episodes we will show how defence delights in circular policies and procedures. These always result in defence always coming back to itself for solutions, and it uses its unique privileges and power to cover up abuse, torture and rape. Defence treats its hard assets better than it treats its victims. The people it will throw away, the people who will not likely even make it onto the Defence Cleanup Crew program. What's that program? It's called the DVA Scrap Heap. Question: how can victims of abuse, tortures and rape in the ADF be treated as if they are the cause of the problem? In effect, the bastard children of defence, left to become like shadows, while perpetrators enjoy the full benefit, personally and financially, from their military career. This has been Background Briefing. Thank you for joining us for the VA ADF newscast. If you have questions or you wish to make contact with us, if you are a victim, or if you want to join a conversation about victims' issues, email newscast@adfabuse.com or go to our Facebook page and post or leave a private message. Our next episode will be early March after Parliament rises from the first sitting session of the year. Thank you for watching and goodbye.